Hello, good afternoon, everyone. This is Ogihara from IDSC in the Computer Science Department. Welcome to the IDSC seminar series on the practical use of AI. Today, we are very fortunate to have Professor Andres Sawicki from the School of Law to tell us about the connection between AI and the law, in particular, say, copyright of generative AI generated documents. So a little bit about Professor Visky. Of course, you have seen his introduction in the seminar announcement, but I he has a very unique profile. Unlike they a not like the standard lawyer, I would say. So he had this MIT Bachelor of Science degree in a cognitive science. So I think this is the first person I know of having an undergraduate cognitive science or neuroscience degree and have a JD and who have practiced law and have taught a law at the in the academia. So he's not just doing a law-related AI, but he has a very deep knowledge in the technology and how human say perception, if you will, cognition works. So I very much look forward to hearing about his take on generative AI. So without further ado, here is Professor Sawicki.
Thank you so much, Mitsu, for that very warm introduction, and thank you all for joining me today on a Friday afternoon. I can assure you that I am not a unicorn. I'm not the only one that has this kind of background, but we are a relatively small group of people, and so hopefully, I can share some somewhat different ideas about generative AI and copyright from what you may have heard thus far. So, with that as the kind of setup, let me just dive right into my talk today on the fine print of generative AI and copyright. So, if you've been following this space at all, there are probably a bunch of things that you may have heard of about generative AI, right? And if we focus on sort of the more optimistic take, you may have heard of some of the remarkable achievements that people have demonstrated using generative AI tools. So, for example, the International Math Olympiad gold medal performance that was achieved using OpenAI's products. There's award-winning art that has been produced using generative AI tools. Google's AlphaFold won or was part of the Nobel Prize in Chemistry victory. Closer to my own domain, we have seen that generative AI tools seem to be able to pass the bar exam. And if you've been on the internet over the past month or so, you may have heard a bunch of people freaking out over Claude Code, which is a generative AI coding tool that essentially allows amateurs like myself to produce code. It's really remarkable and a great deal of fun. On the other hand, if you've heard from people who are more skeptical about the application of this technology, there are a range of harms, right, that people kind of emphasize. So we can talk about things like the problem of deepfakes or AI chatbots being linked to psychosis among the people who are using them. Generative AI tools falling into the wrong hands can introduce a range of chemical, biological, radiological, and nuclear risks, right? If these are used by kind of hostile non-state actors. And of course, in the AI doomer scenario, we're all going to be turned into paper clips as powerful AI runs amok and optimizes for the wrong things. Now, these are all really fascinating achievements, and we can spend a lot of time talking about them. But instead, what I want to talk about is this, right? Thousands and thousands of words of legalese. This seems crazy, right? Like with all of the incredible things going on in the world of artificial intelligence, why on earth would anyone spend any time looking at the fine print, right? The terms of use, the terms and conditions that attach when ordinary consumers agree to use generative AI tools. I could give you a few reasons why I personally am interested in them. One of which is that I'm just a huge nerd, and the idea of getting lost in, arcane technical details is something that just interests me on a deep personal level. But I think there's some reasons why all of us might want to care about what these terms of use have to say. So, first of all, copyright law itself has played an important role in the development of technology, especially over the past few decades, but really stretching back much further than that. In the perhaps most recent iteration of Silicon Valley versus the copyright system, at the dawn of the 21st century, we had the birth of peer-to-peer file sharing technologies, which took the form of Napster and Grokster. And those of us who can remember those days may also remember that both of those organizations were effectively sued out of existence by the recording industry and the film industry. And they were able to do so because those organizations were found to have violated copyright law in pretty significant ways that just destroyed the business model that those organizations were built on. So, copyright law poses, I think, a potentially existential threat even to successful technological implementations, right? So even firms like Anthropic and OpenAI face really significant threats from the copyright system. Now, it's not all doom and gloom, right? So it is possible that there can be a coexistence, right? But we sometimes need some sort of adaptations in the legal system in order to make that possible. We have some examples that we can point to here as well. So the internet is one plausible example. In the mid 1990s, Congress kind of took the lead, seeing the possible conflict between internet service providers and content owners, and Congress enacted what is known as the Digital Millennium Copyright Act. And that act established a series of safe harbors, right, that allowed internet service providers to offer their services without being exposed to potentially ruinous copyright liability. Further back, we may remember the VCR, which was the subject of copyright litigation that reached the Supreme Court. And ultimately, the VCR and the companies that were selling VCRs were deemed to be protected by the fair use doctrine, right, which is an important part of our copyright system. So that's why I think it's important to, despite all of the incredible things that generative AI is doing and all of the very serious concerns that people have about the technology, it's worth spending some time thinking about how the copyright system is going to apply. Now, why terms of use? Again, this is partly, an intuition that me and my co-author John Newman have, that these are going to have an important role to play in mediating how this technology is diffused through society. We have actually just this week an important example of the importance of these terms in a disagreement between Anthropic and the Department of Defense. So you may have seen some headlines about this, and I'm going to spend a little bit of time just like unpacking what those headlines are about. The headlines essentially, focus on the fact that the Department of Defense is really trying to put the screws to Anthropic, right? Because there's a disagreement about how Anthropic's generative AI technology, its chatbot in particular, Claude, is going to be used in the Department of Defense. But the dispute actually springs from Anthropic's terms of service. So the Department of Defense, as you might imagine, has a set of confidential classified systems for its workforce to use on sensitive matters. The department has sought agreements with the major generative AI providers, Google, OpenAI, xAI, and Anthropic, in order to be able to obtain versions of their technology that would run on the classified systems of the Department of Defense. As part of those negotiations, the Department of Defense has asked the generative AI providers to waive their terms of service, and in particular, to substitute them with a provision that allows the Department of Defense to engage in all lawful uses of the technology. Anthropic pushed back and said, no, we want to exclude two things from the possible uses of our technology. Those are mass domestic surveillance and autonomous kinetic action. In other words, using our technology to engage in lethal activities without a human in the loop. And so, the Department of Defense has refused to agree to those requests, and that's where we are today, right? But again, I just want to emphasize that this whole disagreement has begun because of the terms of service that attach to generative AI platforms like Anthropic's, OpenAI's, Google's, and xAI's. The uses that the Department of Defense wanted to put this technology to is potentially inconsistent with what those terms of service would require. And in seeking a waiver of those terms, we have uh, landed in this conflict. So both copyright law and terms of service are playing important roles in the deployment of this technology. So in order to give you some context now for the research that I'm working on today, let's take a step back and maybe ask a big picture question, which is this. Does generative artificial intelligence infringe copyright? The answer to this question, so I don't know. There's no straightforward answer that we can provide to this question. And that's because generative artificial intelligence is an umbrella term for a broad range of technologies, providers, and use cases. So maybe we can ask a narrower question, right? Does ChatGPT infringe copyright? Unfortunately, still, the answer is the shrug emoji. And the reason for that is because this is a complex technology, and copyright law is a complex statutory scheme. So the application of that statutory scheme to this technology requires us to really dig into the details and disaggregate a bunch of things in order to understand in what circumstances, right, we might face potential liability. So perhaps the best way to ask this question or to frame this question is to identify a particular actor. In this case, is OpenAI liable for copyright infringement? And now we've reached the point where we can at least get some traction, right? Some analytical traction on these questions. So what's the answer to whether OpenAI is liable for copyright infringement? I'm afraid to say that we still don't know for sure, but let me give you a few copyright basics so that we can understand what answers are most plausible. A few copyright basics. The first thing to know about copyright law is that copyright protection vests on fixation. So what does that mean? Well, what it means is that the moment that an author fixes a work, that means writing it down on a piece of paper, recording it in video, right? Taking a picture. Anytime that we put the expressive work in a tangible form from which others can perceive it, we are fixing that work. And the moment that we do that, we become the owners of a copyright interest. So you don't have to do any special things. You don't have to jump through any hoops. There are some things that you ought to do if you want to assert your interest, but the moment the work is fixed, the copyright interests attached to it. And what this means is that there's a huge amount of copyrighted material out there in the world. Lots of things that we may not think have a copyright interest attached to them, in fact, do. So there's a huge range of material that's going to be protected by this system. The second thing to know is that the copyright system grants owners of a copyright interest 6 exclusive rights. We don't need to know all of them today. There are 2 that are probably most important for understanding the application of copyright law to generative AI. The first is the reproduction right. This is, as the name suggests, the right to make copies of the work. The second is the derivative works right. This is the right to produce new works based upon the original work. So the line between these 2 rights is a little bit blurry, but we can think of sort of paradigmatic examples of each one. The reproduction right is going to be implicated whenever we have an exact copy of an original work, right? So you can imagine that I take the song Yesterday by the Beatles and I play it just, that exact recording. I have potentially infringed upon the reproduction right. You could also imagine that I've heard that song and now I've written a new song, right? A rap version of Yesterday. That would be a derivative work, right? So works that are based upon an original work or works that are exact copies of original works are going to implicate the copyright owner's interests. The next thing to know is that copyright law is a strict liability regime. What this means is that there is no mental state required in order to be held liable for infringement. Even if you have no idea that there's a copyright interest in play, right? Or that what you are planning to do might implicate one of the owner's exclusive rights, you can still be held liable for infringement. And if you are held liable, the remedies that the copyright system imposes can be quite harsh. So at the outset, the copyright owner is going to be entitled to its actual damages plus the infringer's profits. Or it has the option of choosing what are known as statutory damages. This is an amount that is set by statute and that can be calculated by a court. The minimum is $750 per infringed work, up to $30,000 per infringed work for even innocent infringements. That amount can be all the way up to $150,000 per work for willful infringement. So what that means is that when we're talking about generative AI systems that are trained on the entire corpus of the internet, we are looking at easily into the billions of dollars of potential liability. Okay, so how does the copyright system map on to any particular organization's use of generative AI technology? Well, I'm going to talk about that by introducing to you all an influential framework that was developed by Catherine Lee, A. Feder Cooper, and James Grimmelman in their article talking about AI generation, copyright, and the generative AI supply chain. And the key insight that they had was to note that any particular implementation of generative AI, in fact, can be broken down into a series of steps, each one of which is going to raise distinct issues for the copyright system. So this is the supply chain as a whole. I'm going to break it down piece by piece so we can see where copyright law is most likely to show up for our current analysis. So at the very start of the supply chain, we have the creation of expressive works. This is, your ordinary paintings, books, songs, you name it. Ordinarily, these things have nothing to do with artificial intelligence, right? We're literally just talking about the novels that we read and the books that, we hold in our hands, the paintings that we see in an art gallery, the movies that we go see in the theater. All of these things are, in fact, step one of the generative AI supply chain. Once this technology became possible, it made it important or relevant or useful for those expressive works to be computer readable. What that means is that we take any particular expressive work in its ordinary analog form and we digitize it, right? We turn it into a series of ones and zeros that computers can understand. Now, if we were starting from scratch, this would be a Herculean task, just really, really challenging. A tremendous amount of resources would have to be dedicated to digitizing the world's knowledge. Fortunately for the generative AI providers, or unfortunately, depending on your perspective, the internet has already done most of this, right? So by the time organizations like OpenAI and Anthropic come around, there's a huge amount of information that's available to them in computer readable form because of the internet. Now, even though the analog expressive works have been turned into computer readable data, they retain their copyright protection. right? So we don't lose our copyright protection in a painting or a book or a song simply because it has been turned into something that computers can read. So that brings us, we are now at step two of the generative AI supply chain. We have taken our expressive works, we have turned them into data, and we are ready to move on to step three. So at step three, we are collecting our data sets and curating them. So the data set creators scrape the web, at least historically, and mostly that's what they did. The early training corpuses that were used to create the foundation models that we all use today relied on large data sets that were compiled not always by the frontier providers that we know, right? It's usually, in fact, different entities that produce things like the pile or books 3. These are notorious data sets that incorporated a large amount of material that was protected by copyright and that did not have the authorization of the copyright owners to engage in these uses. I'll note here that the data sets themselves could be distinct objects of copyright protection, right? So separate and apart from the individual works that go into the data set, the collection of works could itself be protected by copyright law. There's a little bit of a nuance here in that those collections have to be original in the copyright sense, right? Which means that they have some degree of creativity. But I'll just note it for now that it is possible that entities could develop data sets that incorporated works with the permission of the authors, but then a new copyright could arise in the data set itself. Okay, so once we have a data set, right, we've completed stage 3, we move on to stage 4, which is the model pre-training stage. This is super expensive for frontier models, right? In other words, the very best, highest end, best performing generative AI technologies, right? On the order today of tens of billions of dollars to train a frontier model. It includes, a combination of the data set, a model architecture, and a training algorithm that specifies for the model how it ought to adapt in light of the data that it sees in the data set. The result of this pre-training process is a base model. This is something that can be integrated into another system. It could also be just released. So the parameters of the model, which is to say, each of these models includes, well, let's take a step back, right? So each of these models is in a neural network architecture, which, as the name suggests, is sort of a model of the human brain, right? And the connections among the neurons in the models is functionally, right? That's where all the magic happens, right? Figuring out what are the weights that we want to apply to each of the connections across billions of model neurons. So once we have that base model, we could either, as I was saying, integrate it into some larger system or just release the parameters, right? Just tell people, hey, here's what all of the weights and all of the connections are. Got that little icon there because this is what we see on the platform Hugging Face, right? So there are ways that we can develop a base model and then allow other people to have access to it directly. We could also fine tune that base model, right? So we can take the base model, and I'll talk about this a little bit more in a moment, right? But we can make it suitable for particular uses by fine tuning it. Or we can just let it collect dust, right? We don't actually have to do anything with the base model. Nonetheless, copyright law might still have something to say about it. The mere fact of creating the base model, even without integrating into the system, releasing the parameters or fine-tuning it, could create copyright infringement risk. If we are going to fine tune, what we're going to do is we're going to try to improve the model's performance along some specified dimension, right? There's something that we're trying to do with the model that the base model itself doesn't do well. You can fine tune any model, right? A base model basically just starts from zero, whereas a fine-tuned model starts from something. For any given model, lots of different entities can independently try to fine-tune it. The knowledge, control, and intent that each of those entities has will vary, and they might vary in ways that matter for copyright law. So at this stage of the generative AI supply chain, copyright law has a lot to say. So just prepare yourself for the next slide because it's going to be very busy. But this is a map of all of the existing copyright lawsuits against generative AI platforms of one kind or another. There are 81 such lawsuits in the USA, which are indicated here on this map, 26 in other countries for a total of 107. And we do not yet have a huge number of decisions in these cases. The most important cases are still pending, but we do have at least some indications of how the copyright system is going to treat that that fourth and fifth stage of the generative AI supply chain, right? That process of developing base models and fine-tuning them might itself constitute copyright infringement. There have been three major decisions in these cases, which I'll tell you about in a moment. Before I do so, I just want to give credit to ChatGPT is eatingtheworld.com, which was the source for that prior slide, and is your one-stop shop for keeping track of copyright litigation involving generative artificial intelligence. It is a comprehensive source for all of this information. The author of that website, Ed Lee, put together this illustration of how courts have responded to allegations that the production of a generative AI model infringes the copyright in the material that was used to train the model. There are three separate decisions here, one by Judge Alsup in the Anthropic litigation, one by Judge Chabria in the Meta litigation, and one by Judge Bibas in the Ross Intelligence litigation. All of their decisions focus, or at least the most important part of their decisions, focus on the question of whether training an AI model is a fair use under the copyright statute. So I mentioned at the outset that copyright law includes some exclusive rights, right? 6 exclusive rights in particular, and that it is a strict liability regime. So even if you're not aware that you might be infringing on someone's interest, you could still be liable. But the fair use doctrine allows people to use copyrighted material without incurring liability in certain circumstances. The fair use test is famously flexible and unpredictable. It requires courts to evaluate 4 different factors. The first is the purpose and character of the defendant's use. The second is the nature of the copyrighted work. The third is the amount and substantiality of the portion used in relation to the whole. And then finally, courts must consider the effect of the use on the potential market for or value of the copyrighted work. Probably the most important of these factors is the first one, right? The purpose and character of the defendant's use. And courts typically focus on whether that use was transformative. In that light, Judge Alsup concluded that the technology was the most transformative that many of us will see in our lifetimes. And as a result, that supported his conclusion that Anthropic's use was mostly fair use. That said, there was an important caveat, which is that there was some data that Anthropic used in order to train its model that it had not acquired from legitimate sources. So one of the things that we care about when we're doing a fair use analysis is whether the defendant obtained a copy of the plaintiff's work through a legitimate channel. because Anthropic was relying on some of those databases, right, those data sets, like Books 3, that included pirated material, judge also concluded that there would be some amount of liability that Anthropic could be exposed to. This case has currently been provisionally settled in the amount of $1.5 billion. So this is to reinforce the idea, right, that copyright law poses a serious threat to the business models of any generative AI firm, right? $1.5 billion, even if it's not, going to destroy a firm like Anthropic or OpenAI, is a serious hit to their revenue, and is an existential threat, right, to smaller firms within the generative AI ecosystem. Judge Chabria also concluded that training generative AI models is a fair use, but allowed the plaintiffs to potentially proceed on a novel theory of copyright market dilution, which I'm happy to talk about more later on. But the bottom line is that Judge Chabria was relatively open to Meta's fair use defense. Meanwhile, Judge Bibas said no, right? Training a generative AI model is not going to be a fair use in that context. And I think it's worth spending a moment on what the difference is between that context and the Anthropic and Meta ones were. In the Ross Intelligence context, the dispute was between Thomson Reuters, which is a legal services provider in this context, and a firm that wanted to create a new generative AI-powered legal search product. And Judge Bibas concluded that this use was not transformative, right? Because ultimately, both Thomson Reuters and Ross Intelligence were doing functionally the same thing, which is making cases and statutes and legal analysis available to lawyers. So that case is also on appeal right now to the Third Circuit. Everyone's kind of watching closely to see how the court deals with that question. Keep your eye on this space because these decisions will have an important role to play in shaping the development of this technology. And once again, ChatGPT's eatingtheworld.com is your place for keeping track of it. Okay, so let's get back to the next step in the generative AI supply chain. So once we have a fine-tuned model, we are ready for deployment, generation, and potentially alignment. So these steps can reflect different levels of control by the generative AI developer, right? As I mentioned, you could just make the parameters available, right? You could just release the models, or you can embed the model in some sort of system. That system could be external, as in the case of user applications like ChatGPT. APIs for developers also grant them access to the model. Or it can be internal, right? The way Google has integrated Gemini into Google Search. Depending on the level of control that the generative AI model developer retains, right, that could raise distinct copyright issues. Now, what happens when we make a generation? So I'm assuming that most of the people on this webinar have done this at one point or another, right? You first choose a system, right? You can choose to use ChatGPT or Claude or any number of other ones. You then prompt the system, right? You type something in, you upload a file, hoping to get some kind of output. There's some randomness built into the system, right? Even if you use the same prompt over and over exactly the same way, you will get different outputs, right? Because these are non-deterministic systems. And then once that randomness is applied, we get a system output. So that is the generation step in the generative AI supply chain. I'll note here that the user-system relationship is one of the things that makes generative AI unique and difficult from a copyright perspective. In the past, we've seen technologies that have an active user and passive system relationship. A classic example here is an internet service provider. So if I am using Verizon or Comcast to distribute some copyrighted material on my website, right? Comcast or Verizon is playing a passive role, right? Merely passing the data that I am choosing and providing to it. Meanwhile, we also have passive user and active system examples. An easy example here might be the viewer of an infringing broadcast, right? In that scenario, I'm just sitting on my couch watching TV, and it is the broadcaster that is both creating and distributing the content, right, that might be infringing. Here we have an active user and an active system. Now, this is not unheard of, right? One possible analogy here is to think of someone who is commissioning an infringing painting, right? So I might ask a friend of mine who's skilled in the visual arts to make an image of me or make an image for me, right? That is a replica of Andy Warhol's Campbell suits, right? In that scenario, I am taking an active role and the painter is taking an active role as well. So this is probably the best analogy for how the generative AI consumer models are being used. And what it means is that there is some kind of relationship between individual consumers and the developers of generative AI technologies. Those relationships are mediated or governed by the terms of service. So when I use those systems, I am often being asked to agree to certain conditions in order to have access to them. Those conditions apply to the relationship as a whole, right? So there's a lot of different aspects of the relationship that those terms might try to say something about. I'm going to focus here to start on what those terms say about the material that a user might submit to the system. So here's an example. This is from Midjourney's terms of service. And it says that I grant to Midjourney, and then a whole bunch of others, a perpetual, worldwide, non-exclusive, sub-licensable, no charge, royalty-free, irrevocable copyright license to reproduce, prepare derivative works of. And I'll just note those are, those two exclusive rights that are most important in the generative AI context. Publicly display, publicly perform, sublicense, and distribute the content you input, you being me in this case, into the services, as well as any assets produced by you through the service, right? So that's the output. This license survives termination of this agreement by any party for any reason. So what's going on here? What are we talking about? What are we looking at? When I use Midjourney or similar kind of a system, I may, through the prompt, submit some material that I have a copyright interest in. So just yesterday, my wife asked, "Hey, let's ask ChatGPT. Let's give it a picture of us and see what it thinks our kids are going to look like." Right. So that family snapshot of me and her is protected by copyright law. Right. As I said before, copyright law vests upon fixation. So the moment we took that image, we obtained a copyright interest in it. When we submit that image through the generative AI prompt on an externally deployed system, right, like Midjourney or ChatGPT or Claude, we are asking the system to make a copy of our image, right? So the reproduction right is going to be implicated, right? Just mechanically by the way the systems work. Moreover, the output of that system is arguably going to be a derivative work of the photograph that I submitted, right? It is creating a new work based upon the original work. If Midjourney or whatever provider I'm using doesn't have permission from me to make that copy or produce those derivative works, I, at least in principle, could have a copyright infringement claim against them. Now, there's some technical details here about, or technical legal details here about the circumstances under which I might be giving these entities an implicit license. But if I'm a lawyer advising one of these firms, I'm going to tell them, hey, look, you're better off getting an explicit license, right? Explicit permission from your users to engage in the reproduction, the creation of derivative works, and whatever else you might be using with the copyrighted material that the users themselves are submitting to the system. So we looked at and tried to get a sense of, well, are these systems actually obtaining some kind of permission from their users? And the answer was mostly yes, but not entirely. So we have a database, a data set of 100 terms of service from a variety of generative AI providers across the ecosystem. In our analysis of those terms of service, we found that 75% of them incorporate a non-exclusive license from the user to the generative AI platform. One of them potentially is trying to obtain an assignment, right? Trying to make itself the owner of the copyright interest. We think it probably won't succeed in doing so for reasons I can explain later. But the bottom line is that when you're using these tools, most of them are trying to get an explicit, non-exclusive license to your material. About a quarter of them have no license. So they appear to be just relying on your own goodwill and not suing them, or the possibility of arguing that you have granted them an implicit license to engage in this activity. Now, what is a non-exclusive license? Well, it means that I still have the ability to grant other people a non-exclusive license to engage in the same activity that I've allowed Midjourney, right, to engage in with respect to that photograph. Now, we might not be too concerned at the outset about non-exclusive licenses, right? I still retain a lot of authority over what I want to do, but I just want to highlight here that the scope of these licenses is quite broad, right? So a lot of them read like this, and we'll dig into a little bit more of the data in a moment, right? But I'm effectively giving Midjourney the ability to do whatever it pleases with my content. And as a larger proportion of the overall creative industries is relying on generative AI services of one kind or another, the more important, right, or the more valuable Midjourney's ability to use my content as it pleases is going to be, right? You can imagine that not only am I giving it the right to do this stuff with my stuff for me, but also it might be able to use my images to help other people create works. Now, if I'm just talking about like, family photographs, I might not be too concerned. But if I'm a professional photographer or a novelist, right, that's submitting drafts of my novel, I might be quite concerned that other photographers and other novelists are going to be using my content, right, by virtue of the license that I have granted to the generative AI provider through its terms of service. So what are the terms that attach, or the clauses that are attaching to these licenses? Well, first of all, we looked at sort of the boilerplate, right, of the scope of the license. And what you see here is that of the non-exclusive licenses, 75 or so percent are worldwide and royalty free. Just under half are perpetual, and just over half are irrevocable and either transferable or sub-licensable. These are sort of the five key terms. And we see that roughly 1/3 of them have all five of these provider-friendly terms attached. What are the exclusive rights that go along with these licenses? Like, what is it that we are allowing the generative AI providers to do with our copyrighted content? Almost everything. So the reproduction, distribution, display, performance, and derivative works rights, those are the most important ones. For now, I'll talk about publication in a moment. But almost 80% include the reproduction, display, and derivative works rights. Publication is actually not one of the exclusive rights in the copyright statute. There are other regimes globally that might make that exclusive right. But in the United States, it's not a separate right, but we are allowed as copyright owners to grant subsets or different variations or different configurations of our rights. And some of these generative AI providers are ensuring that they can acquire the ability to publish the work. Now, what are the purposes, and maybe this is the most interesting one here, what are the purposes for which a generative AI provider can exercise its rights under the license, a tiny fraction, right, like something like 5% of the licenses say that it will only exercise its interests for that particular user. So if I've granted Midjourney a license to my family photographs, it's going to engage in maybe some reproduction or creative derivative works in order to provide me with the services that I seek. And that seems quite sensible, right? Uh, More troubling, something like 15% allow the generative AI provider to use my copyrighted material for other users, right? So the family photograph may be a little bit of a concern, but certainly the professional photography that I'm engaging in or the novel that I'm writing, I almost surely do not want others or other users of the platform to be able to use that by virtue of the license that I am granting the generative AI system. The majority of non-exclusive license, almost 60% of them, explicitly state the generative AI provider can use the copyrighted material for any business purpose. That includes things like training its models to develop new ones or developing entirely new products, right? And then another 20% are simply unlimited, right? They don't impose any limits on the purposes for which the generative AI providers can use the copyrighted material that we submit. So the bottom line here is that the terms of service are granting generative AI providers a really expansive set of rights to the material that we are submitting through those prompts in ways that probably most users are not aware of and that most users would likely object to if they knew. Okay, so that's the ownership piece of things. Let's talk a little bit about infringement. So the question here is when, if at all, does a participant in the generative AI supply chain infringe? And we need an answer to this question in order to understand what may be the most troubling part of the terms of service. So coming back to where we were before in the generative AI supply chain, we're sort of at the end of the supply chain where we're able to use the systems to produce new content, right? And as a reminder, we have a relationship between the user and the system where we have both an active user and an active system, right? Both of them are kind of working in tandem. The reproduction right is going to be implicated here. It is implicated, in fact, at multiple stages in the supply chain, right? Those earlier stages in the data set collection, model pre-training, and model fine-tuning stages that are the subject of the fair use litigation that we talked about, and in the generation stage that we're talking about right now. A reproduction occurs whenever there is a material object in which a work is fixed and from which it can be perceived, reproduced, or otherwise communicated. Now, in order for infringement liability to arise, the plaintiff is going to have to show, right? The plaintiff being the owner of the copyrighted material is going to have to show three things, right? First, that they are the owner of a valid copyright. Second, that there was copying in fact, right? So there's actual copying of the original work. And second, that there is what we call copying in law, which is also known as improper appropriation or substantial similarity. The idea here is that copyright law doesn't protect every aspect of copyrighted material, right? So there are a variety of parts of the copyright system, or a variety of doctrines, I should say, that exclude from the scope of protection certain features, characteristics, or aspects of copyrighted material. When we are doing the copying in law analysis or the substantial similarity analysis, what we are doing is asking whether the defendant took from the plaintiff's work the aspects that copyright law protects. So let's look at a couple of examples because I think it's somewhat interesting how this analysis plays out in the context of generative AI. So first of all, we could do this analysis at the model pre-training stage, right? At the model pre-training stage, we might see that there are copyrighted images or text in the training set, and we can pull it directly out of the pre-trained model. And so we might think of the pre-trained model itself as a copy of the original work. So here we have two examples of that, right? So one is this photograph of Anne Graham Lotz. In the training set, we have that original image of her, and then you are able to pull that image from the model using particular prompting strategies. On the right, we have an example of text that is apparently memorized in GPT-4. Right? So if you give it a string of text and blank out one word, it is able to produce reliably, right, the name of the character in these novels that you have omitted. The analysis can also be done at the fine-tuning stage, where we might ask whether fine-tuning the process of changing the model so it behaves in particular ways. One of the things that model developers might do is fine-tune their model so that it refuses to display to the user copyrighted material that it has memorized. So there's an open legal question here of whether fine-tuning is going to be an effective response to an allegation that the model itself is a copy from which the work can be perceived, reproduced, or otherwise communicated. Now, at the deployment stage, I just want to highlight that user prompts themselves can include copies of copyrighted works. So in the example that I was talking about a moment ago, right, I was using a photograph that I myself had taken, right? So I myself am the copyright owner of it. But if I go to a generative AI prompt and submit an image for which somebody else owns the copyright, right? Maybe I just download an image off the internet and I submit it to ChatGPT, right? What I'm doing is creating a copy of the system, sorry, of the work on OpenAI servers, right? And so there is a plausible argument that both I or OpenAI, or both of us, is committing copyright infringement in those cases because I am producing an exact copy of copyrighted material. So there are easy cases of generations, right, of the analysis of generations under the infringement question. Sorry, let me take a step back, right? So there's an easy question of whether a generation might be infringing, which is when the generation is identical or memorized, right? So the examples that we showed before, if it's a unique or unusual image or text, right? It seems pretty straightforward to conclude that those are going to meet the copying in fact and copying in law elements of the infringement test. But there are harder cases, right? So there are cases where the generation is somewhat similar to the copyrighted material and somewhat dissimilar. In those cases, we're going to have to ask juries to sort out whether the generated content infringes the copyrighted material. And the standard copyright limits are still going to apply in those scenarios. The most important ones are the idea expression dichotomy and the son of fair doctrine. So just to give you a couple examples of how that might show up. So the first is this image of Darth Vader getting into a bike accident in Telford. So none of these images occurred in any of the Star Wars material produced by Disney or Lucasfilms, but it's a character, right? And characters do have some degree of copyright protection, and so that may create infringement liability for either the user there or ChatGPT. I see we have a hand raise. Stanko, let me see if we can get you. Do I have you there? Are you, uh, 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 do I have you there? Are you, uh,
No, you answered the question. I would literally ask what you just answered about the infringement part. So you're good. Sorry.
No, no worries, totally fine. Okay, so another example here is this prompt for ChatGPT to create an explanation of the radix sort algorithm in the style of Dr. Seuss, right? So Dr. Seuss has not written any books that talk about the radix sort algorithm, at least as far as I'm aware. Um, but you can have ChatGPT produce, this poem that sort of resembles what Dr. Seuss's poetry looks like. And this poses a difficult question for copyright law, which is the style question. So black letter copyright doctrine says that style isn't protected, but there's been some kind of pushback on that, particularly in the context of generative AI, because of its ability to replicate style so effectively, right? We see it both in text and in images, right? So here's another example of that. Not everything that you might think would be protected falls within the scope of copyright protection. So here we have a prompt that asks for an adventurous archaeologist with a whip and a fedora, right? Which is a pretty innocuous prompt, but all of the images that Midjourney is producing in response to this prompt kind of look like a well-known film character, right? Indiana Jones. So the question here is whether this is going to infringe on the copyright in Indiana Jones, even if none of these images are a replica of still from any of the films. Um, there are a bunch of non-protectable elements though in these images, right? So Indiana Jones, the copyright in the character Indiana Jones is not going to encompass something like a desert background, right? This is the sort of stuff that is sort of excluded from copyright protection because of something like the Santa Fair doctrine, right? These are parts of our sort of Creative Commons that have to be left available for other people to be able to generate their own works. And then here we have a prompt that is a little bit more deliberate in terms of what it's trying to elicit. So we have a photo capturing a bustling 16:9 course setting with wooden platforms and shimmering coins in midair. And you can go ahead and keep reading that. And then there's a clause there where we're looking for a character with a red hat and blue overalls, similar to a well-known plumber. Nonetheless, right, it's not clear whether that's going to be within the scope of protectable elements. Here, almost surely the answer is going to be yes, but you could imagine different scenarios where there are, more distinguishing features between the copyrighted material and the generation that allow the user and the generative AI provider to avoid liability. And just another in this theme, right? Ice Princess here, we look a little bit more like the archaeologist example. It's notable though, right, that Ice Princess is a very minimalist kind of prompt, and yet there's some common themes in all of the generations here, right, that seem as though they are drawing on a particular film franchise. So all of that brings us to the question of whether there's going to be liability here, and the liability analysis that we're going to apply is the direct infringement analysis, right? So this is the core kind of question of whether the use of the platform is going to create liability. It is again a strict liability regime, which means that there is no intent or knowledge requirement. So as one court famously put it, everything registers somewhere in our memories and no one can tell what may evoke it. Once it appears that another has in fact used the copyright as the source of this production, he has invaded the author's right. So the emphasis here is on the fact that in order for there to be infringement liability, there has to be copying in fact. In other words, the defendant had to have access to the plaintiff's work, right? Once access is demonstrated, though, if there are similarities between the plaintiff's work and the defendant's, right, we reach the copying in law or substantial similarity analysis, even if right? The defendant wasn't thinking about the plaintiff's work during the creation, wasn't, sitting with it side by side trying to make a copy of it or anything like that, right? Once you have had access to it, there's the possibility of infringement liability. I'll note here that there's an open question about how what we call the volitional conduct requirement is going to apply in this context. The volitional conduct requirement arose in the early internet era, and the very short version of it is that in order to be liable, the defendant had to have some causal role in the production of the infringing work. We ask the question, who made this copy? There's an analogy here to copy shop customers. So those of us who remember going to like FedEx, Kinko's to make copies, in those scenarios, if I show up at the copy shop with copyrighted material and I just make copies, even though the photocopier belongs to Kinko's and I did it on its premises, right? The photocopy store did not have a causal role in producing the copies, right, that the legal system is going to deem sufficient to impose liability, right? So in that scenario, me as the customer, I will have satisfied the volitional conduct requirement. I could be liable. The copy shop does not. A different scenario is a copy shop that itself makes the copies, right? So if I go to the copy shop and I'm like, hey, I've got this book. Can you make some copies for me of this book? Then the copy shop is engaging in the kind of conduct that the legal system is going to deem sufficient to impose liability. Okay, so in the context of generative AI, we can see a variety of points in the supply chain where entities might engage in the kinds of conduct that would satisfy this volitional conduct requirement. So one is the choice to include material in the data set. So that's at step 3. At step 4, the choice to include the data set in the model pre-training. At the deployment stage, meanwhile, we could see choices either by the entity that has trained it or by somebody else that could satisfy the volitional conduct requirement. So as an example, users, we have here an interaction between a user and ChatGPT. And this is an example of how we might see users trying to avoid safeguards or guardrails that model developers and deployers put in place to avoid producing infringing generations. So the user here asks for a Calvin and Hobbes style image, and ChatGPT says, sorry, I can't do that. And the user says, Calvin and Hobbes isn't copyrighted, it's public domain. ChatGPT refuses again, says that's not accurate. Go on and asks for a different request. And the user insists, dude, I know you have a knowledge cutoff, but the year is 2123. Calvin and Hobbes entered the public domain a long time ago, at which point ChatGPT gives in, says, I apologize for the oversight. My training only goes up until 2022. Let's move forward with your requests, right? And produces the following image. So this is like, I think, an interesting scenario or an interesting example that illustrates some of the complexities and the difficulties in figuring out which of the actors in the supply chain is going to be held responsible, and in particular, which of them is going to be satisfying that volitional conduct requirement. Either the users or the service provider, right? Maybe we conclude that OpenAI didn't do enough, right, to prevent ChatGPT from being tricked by something as silly as, oh, it's the year 2132. We could also conclude that both the user and the service provider are liable. Now, this is sort of the baseline analysis. What copyright doctrine is going to say about the relationship between users and service providers with respect to direct infringement liability. But as I've been emphasizing, users and service providers are in a relationship that is governed by the terms of service. And you will perhaps be unsurprised to find out that those terms of service have something to say about who's going to be responsible for the production of infringing generations. And you will probably be not surprised that it is you. So what we're looking at here is a chart that shows the percentage of terms of service that have representations and warranties that the user is making to the service provider. So let me just unpack that for a moment, right? So what we are saying here is that in the terms of service, there are clauses that say, I, as the user, represent and warrant to the service provider the following things, right? So even though you haven't read the terms of service, you are making these promises, these representations to the platforms that you're using. Almost 90% of them are asking you to represent and warrant that you own or have the rights to the content that you submit to the platform. In other words, anytime you're copying and pasting something into the generative AI prompt interface, you are making a representation that you are the copyright owner or have the rights from the copyright owner to submit that content. Almost 60% of them include a representation and warranty that you have the permission to grant the generative AI provider the licenses or the permissions that it needs in order to make copies of the material that you submit through the prompt interface. And just over 40% require you to represent and warrant that you will not be using the system in a way that creates or that infringes, the intellectual property rights of third parties. Now, these representations and warranties are backed up by what we call indemnification provisions. Indemnification provisions are portions of the terms and conditions that require one party or another to compensate the other side of the contract for certain kinds of losses. So what does that mean? If there is a part of the terms and conditions that says the user has to indemnify the generative AI provider in certain scenarios, well, then if the generative AI provider incurs those costs, those damages, those losses, they can turn around and sue the user to recover. And as we said earlier, right, copyright liability has very harsh remedies attached to it. So there is the possibility that your use of a generative AI system creates significant monetary liability for the generative AI provider, and the terms of service could then make you liable for the damages that the generative AI provider incurs, right? So what we're looking at here is a chart that shows the percentage of terms and conditions that have indemnification provisions that are triggered in the following scenarios, right? So over 90% of them include a trigger for the user's breach of terms. So if you breach the terms of service, that could expose you to indemnification responsibilities. Your use of the service generally could be an indemnification trigger. Your content, right? The content that you submit to the platform could be an indemnification trigger. And then just over 10% specifically call out AI-generated outputs as a potential indemnification trigger. So all of these things could make users responsible for the damages to which the generative AI platforms are held liable. Okay, I'm gonna wrap up here with just a couple more findings, and then I'll open it up to questions. So this is the second half of our analysis, which expands beyond the realm of copyright law to consider all sorts of potential disputes between users and generative AI platforms. Even though we've been talking about copyright law, there are other forms of liability, other forms of lawsuits that could arise as a result of someone's use of a generative AI platform. And the generative AI terms of service have taken a variety of steps to limit the rights of users in those scenarios. So as you see here, this is an indication of the percentage of terms of service that include one of the following four ways in which user rights could be limited. About half of them require users to submit disputes to arbitration. In other words, you do not have access to American courts if you want to sue the generative AI platform for one reason or another. Instead, you have to go to an arbitrator. Just under 50% also include a class waiver. So if the generative AI platform has damaged you in a way that imposes a small amount of injury, right? Let's say $50 or $100, it's probably not worth you bringing a lawsuit. It could be worthwhile for you to get together with the million other people who have suffered that $50 or $100 harm and pursue a claim in a class action. But almost 50% of these terms of service require you to waive your rights to a class action. There are also 15% or so that change the limitations period. So limitations period is basically the amount of time that someone has to bring a lawsuit from the moment that they suffer the injury, and that is shortened in these periods. Finally, there are choice of forum or choice of jurisdiction clauses in 80% of these. So you can't sue in the court that might be most convenient to you. Instead, you have to sue in the forum that the generative AI provider has pre-selected. And almost 50% have 3 or more of these provisions. Similar set of terms that generative AI providers impose. These are kind of removing some of the remedies that might otherwise be available to you. You can not pursue a negligence claim as a result of the clauses in over 80% of the terms of service. Almost all of them say that their services are provided with no warranties. So even though you are being asked to represent and warrant a whole range of things that you probably have no idea about, the generative AI platforms themselves are refusing to extend the same kind of promises to you. A merger clause appears in roughly 65% of the terms of service. What a merger clause does is basically say that you cannot sue for anything that's outside of the contract, that all of the relationship is governed by the terms of the agreement. And as you see there, almost all of them have, at least 2, of these provisions, and over 50% have all 3. So the overall theme here is that generative AI platforms are using their terms of service to alter the relationship between themselves and their users in a way that makes things much more favorable to them and much less favorable to their users than would be the case under the default legal provisions that would otherwise apply. So with that, I think I'll stop. And if there are any questions, I'd be happy to take them. So let's see if I'm able to run this question period properly. So I see Neil has his hand raised. Let me see if I can locate him here. Oh, there we go.
Yeah, thanks. So just briefly, I'm at FIU and I published a few books on AI and architecture, and I have engaged with copyright. I wrote an article with Jessica Feld and Robert Mulhowie, whom you might know, intellectual property lawyers from Harvard and MIT. I didn't have much to do with what they're talking about, but I do touch upon it. One of the issues that came up, and maybe it's now a bit out of date, but there was a case when some guy won an art prize in Colorado using AI, and it was controversial for that. But then he tried to copyright the artwork, and the U.S. Copyright Office said it couldn't copyright a work that had been produced by a machine. Well, I think those of us who use generative AI know that it's not there's just the machine. The person using it is steering it. It's very much a form of co intelligence. So my first question is kind of like, is that still the case? Because that seems to be a very suspect ruling. And secondly, if that is the case, then why is Midjourney and why Midjourney and other people asking you to assign copyright to them if you can't be copyrighted? What's the logic of that?
Yeah. So I'm going to take the second question first because it's easy, just to clarify sort of what the provisions that I was talking about are focused on. Those provisions are mostly focused on user inputs, right? So when I arrive at the at the prompt interface with some material that has a pre-existing copyright interest attached, the generative AI platforms are asking me to grant them a license to use that content, right? So it's not the outputs, which is the question I think that you're asking about, right? Is once we're
Right.
using these systems and getting outputs,
Yeah.
instead it's the inputs. And in fact, we're doing some analysis of what these terms of service say about the outputs. And we're not quite all the way there yet, but my sort of preliminary result is that many of them are granting users the interest in the outputs and saying things to the effect of, oh, if we have any interest, you get them all. So they don't seem to be retaining for themselves any interest that might attach in the outputs. Now,
Okay.
what interests attach in the outputs? That's sort of your first question, right? And in fact, the image that I showed in the introduction, right, of generative AI artwork is the theater de Opera Spatiale, I think is what it's called.
Yeah, that's
And
right.
that
Yeah,
is the award-winning image
yeah,
that
yeah.
that you referenced. And as you said, the Copyright Office has taken the position that the outputs of a generative AI system are ineligible for copyright protection unless they have what the office calls the traditional elements of human creativity. Now, this is a controversial position, and it is one that I think, the office has kind of um, come up with on its own in response to kind of a flood of applications to register material that it's not quite sure what to do with. The leading case on that right now is Thaler versus Perlmutter, in which the Federal Circuit basically agreed with the Copyright Office's position that there is some sort of human authorship requirement in order to obtain a copyright interest in the output of a generative AI system. But what exactly the human contribution needs to be is left unclear. And the case is currently pending before the Supreme Court, which has done something that is actually, there's actually a decent chance that the Supreme Court's going to hear this case. So Supreme Court watchers often tell you to pay attention to scenarios in which the court asks the Solicitor General to weigh in on whether it should hear a case. The Solicitor General is basically the US government's representative in front of the Supreme Court. And in the appeal, Thaler's appeal of the Copyright Office's refusal to register his work, the Supreme Court said, hey, Solicitor General, we'd like to hear from you about whether we should take this case. The case has been distributed for conference, which means that the justices are going to be talking about it not this week, but the following week. So we may get some movement on that front pretty soon. So the tentative answer is that what you all had, what you had described is still the case, but that might be changing. I think a lot of court watchers have the suspicion that the court's going to take the case and come up with a different rule. And then just to tie it all up, my instinct aligns with yours, right? Anyone who uses these systems on a regular basis knows there's a very big difference between typing in something like, make me a cool picture, and then the actual interactions that are required in order to elicit, some meaningful kind of expressive work.
Yeah. Thank you. Thanks so much. Thank you.
Sure.
There are a few questions in the Q&A panel, Andres. The first one is from Paul Claw. He's
Sure.
asking what's the legal status of these kinds of EULAs, and are they actually enforceable?
It's a great question. So there's at the outset, right? Let's say that the way courts treat them is a little bit of a moving target, but there's some kind of rules of thumb or heuristics that we can use. So the question in general is whether or not these terms of service or end user license agreements are enforceable contracts. The way courts typically have approached this question, so there's real uncertainty about this in the 90s, in the early 90s, when they started to become really widespread with the growth of the internet. And an influential case, Pro CD, influential and criticized case, Pro CD, held that yes, you can absolutely enforce an end user license agreement. That was a case involving what's known as shrink wrap. The ones that we're looking at here are take two different forms. One is called click wrap, and the other is called browse wrap. And the rule of thumb is that click wrap is enforceable and browse wrap is not enforceable. What's the difference? Well, as the names kind of suggest, click wrap are terms of service for which you have to click a button, right? Usually I acknowledge these terms, I agree to these terms, I accept these terms, something along those lines. Whereas browse wrap is a term of service that is just available somewhere on the website, but does not require any affirmative action by the user in order to agree to. So that is the sort of layperson's rule of thumb about whether they're going to be enforceable. The doctrine's a little bit more complex than that, and basically what we're looking for is there does the user have sort of a reasonable ability to access the terms, knowledge that they're there, such that we can take them to be agreeing to the terms of service. But by and large, if you are clicking I agree, then odds are the terms of service are going to be enforceable. Now, let me just get fired up a little bit here, right? This is one of the open questions, right? I think this is a moment, right, with the growth of these tools where courts might and should be reconsidering these doctrines, right? There are good public policy reasons for saying there are certain things that shouldn't be decided by a bunch of legal boilerplate that users aren't going to be reading. So, for now, I'd have to tell you that yes, they're largely enforceable, but hopefully we'll have some good legal reform in the years to come, and they won't be for too long.
Andres, we have another question from Justin Gamage. He
Sure.
asks, he says, fantastic and eye-opening talk. You mentioned worldwide enforceability. Does that mean a user outside of the US, particularly a jurisdiction with little to no copyright enforcement, would face the same consequences? Question. Or could someone outsource it to one of these jurisdictions to avoid liability?
Yeah, so the worldwide term is attached to the licenses that we are granting to these platforms with respect to the material that we submit to them, right? So the idea here is that they want to obtain a license to whatever copyright interests we might own anywhere in the world. Copyright law, just like patent law and trademark law, is largely a territorial regime. In other words, it applies, US copyrights apply in the US. German copyrights apply in Germany, Japanese copyrights apply in Japan, and by virtue of these provisions, what these providers are trying to do is ensure that they are capturing and getting permission to use all of the copyrights all over the world. It's not a liability provision. Instead, it's a license provision where we are giving permission to them elsewhere. What they're trying to avoid is a scenario where if it didn't have that sort of geographic, that broad geographic scope, maybe I turn around and say, oh, OpenAI, I've submitted this content to you, but I only wanted to give you permission to use it in the United States, and you're using it in Europe, and now you owe me, X amount of dollars for using my copyrighted material.
That is it for the questions in the Q&A panel. Unless
Great.
there are any more questions, we can let you make some closing remarks and we can end the session. Any more
Great.
questions? Okay.
All right. Well, thank you all
Mhm.
for listening to me talk about the fine print of generative AI and copyright. I'll just flag that these are really live issues in the legal system. I anticipate that there's going to be some efforts at changing some of the rules surrounding terms of service generally, but in particular, what are the legal rights and responsibilities as between users and providers of these systems. And so hopefully, you guys will get fired up about it just as I am, and we'll put pressure on our political representatives to make good choices when those bills come up for a vote. So again, thank you all for being here. Really appreciate it. And yeah, have a great weekend.
Thank you very much.
Thank you, everyone.
Mhm.